Let's go to Ronald Chapman now, who is a federal defense attorney who has tackled healthcare fraud and drug trafficking cases. He's also the author of Fight the Feds, Unraveling Federal Criminal Investigations. Mr. Chapman, thanks for being with us. Much has been written about the unprecedented nature of this investigation. Where do you come down on whether a former president should be charged and whether he should be charged in connection with this case?
Well, that's a tough question. If the evidence supports it, certainly he should be charged and he can be charged in the case. But the question is here, does the evidence support it? In the grand jury, only 12 need to vote to indict. But obviously, when a prosecutor wants to indict, they want to make sure that the indictment lands and they get a conviction. That's a tougher story without being able to take a look at the evidence and the testimony outside of Michael Cohen's statements.
3 jurisdictions looking at Donald Trump, the former president. There's Jack Smith, the special counsel, finding Willis down in Georgia with the Fulton County DA and the grand jury there. And there's also this case. A lot of people say this is the weakest of the cases. Would you explain that prosecutors don't coordinate with each other as to who is going to indict the former president first, if any of them will?
Well, we've seen some reports that there's coordination between state and federal agencies here. I can't speak to whether or not there's coordination between 2 state agencies, meaning the Manhattan District Attorney and then also the prosecutors down there in Georgia. That remains to be seen. However, I think a lot of us in the legal community are surprised that this state case is going to go out in front of the federal case that's being investigated right now. Obviously, United States attorneys like to keep their investigations secret and don't like a lot of discovery being produced ahead of time. I would have expected the federal case to move first and the state cases to happen later, but that's not what we're seeing here.
So if there is coordination between, for instance, the federal case and a state case, in this case, Jack Smith and Fani Willis, what separates that from people making the allegation that the system is out to get the former president?
Well, I think, when we say the system, a lot of people just refer to one system. But what we have here are several different systems. We have a DA in Manhattan who's individually evaluating evidence. At least that's what we hope is happening. We have United States attorneys who are special prosecutors evaluating their own case. And while this prosecution in Manhattan may seem to be somewhat politically charged, given that it is from conduct that was a long time ago, coming on the heels of Trump being a presidential candidate for the United States, we'll really know more answers to that when we actually see the evidence they have against Trump. I think to those people who say the system may be out to get him, I would say we need to see what the evidence shakes out to be before we can make the determination that a prosecution is solely politically charged and as a result of the system being rigged.
As you know, paying hush money is a misdemeanor. How it is documented, however, on the Trump organization's books and whether it covered up a campaign finance law violation is where it becomes a felony. How tough of a case do you think that will be to prove?
Well, I think it's a very tough case. We've got a couple of hurdles here. The first being a potential statute of limitations argument, which I haven't seen much written about, but is something I would be looking at if I was Trump's attorneys. Then the next hurdle is going to be proving that this false business documentation was designed to cover up a criminal offense, which is what makes it a misdemeanor. What makes it a felony, punishable by, I believe, a statutory maximum of either 4 or 5 years in prison. That's going to be a tough case. What you have to show in this case is that Donald Trump knew that the hush money was being paid, knew that the business documentation was designed as a payment to Cohen to conceal the original business purpose. And with Donald Trump having affairs all over the place, business affairs, it's not expected that he would have specific knowledge unless they can show emails, text messages, or some other business documentation that was seen by him that he had actual knowledge. Now, I've got to presume that the Manhattan DA has that information. Otherwise, this case is probably dead on the doorstep. You've really got to have that communication, and probably in writing.
From a legal standpoint, does it matter that Michael Cohen went to prison already in connection with this case, spending more than a year behind bars and also going back to prison when he threatened to write a tell-all book about it? Does it matter that he spent time in prison and then testified before Congress saying that he was acting at the direction of the former president, and then the former president wouldn't have to defend himself in a court? Does that matter?
I think where this matters is the fact that he has already done his time, and he's not going to the grand jury and potentially testifying on the stand here for the sake of reducing the amount of time he may be in prison. That actually makes him look like a more credible witness than if he was pending sentencing for a charge like this or was looking to get a better deal. I certainly think that the Trump team will use that information, that he's a felon, in cross-examination of Michael Cohen. But it doesn't seem in this case like he's trying to make a deal to benefit himself. This is all happening after the fact.
You know, reporters love to ask these questions, and you attorneys hate to answer them. But if you were representing the former president, how would you defend him?
Well, first, I would use all the procedural mechanisms available. Like I mentioned, the statute of limitations. There's an exception to the statute here where you're continuously absent from the state. I don't know Trump's travel plans or how often he was outside of the state, but I would challenge that continuously absent grounds. Then I would look at the discovery, and I would start challenging the veracity of the statements that Trump had knowledge, assuming that there isn't any specific documentation of it. And if there is, I would want to look into whether or not that documentation was authored by Trump or known to Trump. Again, we're going to see a lot develop once this indictment is unsealed. It will contain specific allegations that tell us what evidence they have, as well as during the discovery process. And I don't know whether this case is triable, but I think we'll know pretty soon as the information comes out.
As you know, on Law and Order, they managed to wrap the entire case up in an hour on TV. If you were a betting man, how long do you think it will be, even if this case was indicted tomorrow, before it winds up before a jury?
Absent a quick plea, I would expect we would see this process play out as 18 months or more. These cases don't resolve quickly if they're going to trial. I'm sure the Manhattan DA wants this case tried before the election. I don't think there's a chance of that happening, given that we're dealing with a former president of the United States who's now being potentially charged with a state felony.
And that sticks it right in the middle of 2024. Ronald Chapman, a federal defense attorney. Mr. Chapman, thanks for being with us this evening.
Hey, thank you so much.
And